Hello, everybody. I just want to talk very quickly about a case that has come to my attention. Well, I've actually been following it, if I'm honest. And it's to do with serving notice on tenant and then completing the claim forms to court. Now, what's really interesting about this particular case is what is the definition of litigation? Now, in my professional capacity, I will conduct certain tasks for landlords. So I will complete Section 21 notices and I will complete Section 8 notices for those tenants. However, what I won't do is I won't then go forward and start completing the claim forms for landlords. There's two reasons why I don't do this. Firstly is because it's too time consuming and it's just not what I enjoy doing. But secondly, it's outside of my scope of professional indemnity. So although I have a good legal mind, I have a law degree, I am not currently a registered or regulated solicitor. So there's a certain amount of works that I am not allowed to legally do. And completing claim forms is one of them. Now, this is under the Legal Services Act of 2007. And this particular case is focusing on that pretty much completely. So this is Baxter versus Doble. And Ms. Doble was the paralegal who completed the section, I think it was a section 21, and then went on to complete the claim form and the claims particular for the landlord, and basically act as the landlord's representative throughout the proceedings. Now, although Ms. Doble did go and get everything double checked by her client, the landlord, the judge in this particular case did turn around and say that the things that she was doing was actually litigation, and she shouldn't have been doing it because as a paralegal she wasn't regulated and she wasn't legally able to. I think this really demonstrates and puts into stone for me the fact that there are lots and lots of people out there claiming to be eviction specialists who aren't regulated solicitors. Now, I'm not going to knock anybody, I'm not going to name and shame because that isn't what I am about. But I think for landlords, you need to be really, really careful about who you are using as eviction specialists. Make sure they are regulated solicitors doing the job for you properly. Because under the Legal Services Act, if you or your assistant, whatever you want to call them, are found to be in contempt of court, that's a prisonable offence of 2 years. So you've really got to consider who you're using. And I know it's expensive to go to court and solicitors are expensive. They're expensive for a reason. They're expensive because they're also protecting you. The other thing I'd like to say on this is letting agents. Letting agents, you cannot be completing claim forms for your landlords. This again is litigation, and then this case has really highlighted that. So I think it's important to understand as a landlord who you use to help you with regards to an eviction process. Yes, somebody can help you with regards to issuing Section 21 and Section 8 on your behalf. That's where their job needs to stop, as mine does. If you're going to have somebody complete the forms and the claims particular for you, that needs to be a regulated solicitor, nobody else. Letting agents, you can issue the Section 21, you can issue the Section 8, that's where your job needs to stop. You can't do the claim forms. Even if you're just completing it and getting landlord to sign, you still could be treading on really thin ice. So I would say the practice needs to stop. So the case again, if anybody wants to have a look at it, is Baxter v Doble. I will put a link to the nearly legal sum up of it because Giles does sum everything up perfectly, and you don't need to Google anything after that. So you can have a read through, but yeah, just looking at this case, it really does manage to clarify everything from moving forward, I think, where you need to be really careful who's doing your claim forms and who is doing your particulars of claims before you go to court. Thank you.